All right, welcome back. Welcome back. Okay, hope everyone's doing well. Sure you'll be occupied tonight, but you're with me now, so baseball doesn't start quite yet. Does anyone have night classes tonight? It's gonna be rough attendance for teachers tonight. It's gonna be tough. Please sign in to the attendance if you haven't already done so. Okay. All right. Questions or anything on your mind? Any questions? No? Okay. Very good. Today we are starting a new topic, but it's a topic we've considered before. And today's topic focuses on another provision of the 14th Amendment, which is the Equal Protection Clause. Right? We started with the Privileges or Immunities Clause, in cases like Slaughterhouse and Bradwell. We then moved on to the Due Process Clause, which covered a lot of ground, in cases like Lochner, Mueller, Atkins, Meyer, Pierce, leading to Caroline Products, and Lee Optical. But now we move away from the Due Process Clause and back towards another provision of law, which is the Equal Protection Clause. Now, I'm not teaching them in this order because that's how they appear in the Constitution. They do, right? It's privileged immunities, then due process and equal protection, right? That's the sequencing they appear in. I am teaching them this order because that's the sequence in which the Supreme Court, considered these topics, right? We started with Bradwell. That killed privileged immunities. We then moved on to due process cases. And by the time we get to the New Deal with Caroline Products and Lee Optical, they say no more due process. We're not doing that anymore. So what's left? Equal protection. Okay. Now, I mentioned earlier we've already done equal protection, and we did in a few cases that aren't very well looked upon today. Of course, I'm talking about Plessy, right? Plessy was a decision from 1896 that established a rule that racial segregation was just fine so long as the accommodations were equal. Right? This was a separate but equal doctrine. And Plessy would remain in the books for 5 decades, right? That precedent allowed the growth of Jim Crow laws throughout the American South and a couple northern states as well. The Jim Crow laws grew in large part because the judiciary sort of said, no thanks, no problem, we don't want to get involved with this. They sort of took their hands off. That process began to shift in the 1930s and 40s. And it largely began gradually. The NAACP had an organization called the Legal Defense Fund. And the Legal Defense Fund decided to bring very strategic forms of litigation to try to challenge the Jim Crow laws. The leader was a guy named Charles Hamilton Houston, a very prominent attorney. And his disciple, his mentee, was someone named Thurgood Marshall. Thurgood Marshall had become a justice. He's also attorney general. Did anyone see the movie Thurgood? Anyone see it? It was okay. It wasn't about the Supreme Court. It was about Thurgood Marshall's work on a criminal trial. So it wasn't even what I thought it would be. But it was an okay movie. but these were very prominent attorneys. And they developed a strategy to try to attack separate but equal. The first phase of this strategy was to show that the separate accommodations were not, in fact, equal. That is, the schools for the African American students were inferior. There wasn't enough funding, the equipment was bad, the facilities were worse, right? They weren't actually equal. And the idea was, look, we can't challenge Plessy yet, but let's get the courts at least to recognize that there are unfair, unequal conditions given the Plessy doctrine. And this strategy brought some success. They focused primarily on graduate schools, right? Upper division graduate schools. And I think the most famous example is one close to home, which is TSU, right? Why does Texas Southern, across the highway, have their own law school? The reason why is because the University of Texas at Austin was segregated. They would not admit black students. And they were sued. And so instead of admitting black students, the state said, OK, we'll make a African American law school. And they established it at TSU. And the Supreme Court says, no, that's not fair, right? Why? Because UT Austin Law School is a better law school than TSU. OK, well, I mean, I'm not trying to knock on TSU, but it was certainly true at the time. And this was a case called Sweat versus Painter, Painter, Sweat versus Painter. And the court said, no, this is not equal. This is separate and unequal. OK. These sorts of cases came along, gradually. They weren't attacking Plessy facially, but they were suggesting that maybe the Plessy doctrine didn't have the legs they needed it to. By the time we get to the early 1950s, the strategy shifted. Rather than simply focusing on graduate programs, right, college degrees, the NAACP decided to focus on primary schools, K through 12. And there's an excerpt from Thurgood Marshall in the book, which I think explains it quite well. Marshall explained that there was some, I don't know how to describe it, just some belief that it was OK for older students to be exposed to African Americans, but they didn't want their young kids doing it in kindergarten. And Marshall said, I didn't really understand it, but it didn't matter. But eventually they said they had to go after the core, which was K through 12 education. And this gave rise to the challenge we now know as Brown versus Board of Education. It wasn't a single case. It was several cases that were consolidated. There were challenges to segregation laws in Kansas, in Virginia, in South Carolina, in Delaware. Delaware? Yeah, even Delaware. Delaware had actually a huge segregation problem. It's not well known. But basically, Delaware was an offshoot of Maryland, which was an offshoot of Virginia, right? Those states you don't think of as Southern, but they had a very strong segregation law in effect. The lower courts in the South Carolina, Virginia, and Kansas cases upheld the segregation law, citing Plessy. The Delaware Supreme Court actually ruled that the segregation was unconstitutional under the state constitution, that wasn't federal. There's another case, which we'll get to in a little bit later, called Bolling against Sharpe. Bolling was a challenge to the federal law, the federal segregation law in the District of Columbia. Right? If you went to a DC public school, they were also segregated. Right? So you had these two sets of challenges, one to the public schools in Kansas, Virginia, South Carolina, and Delaware. And the second case was a challenge to the segregation laws in effect in the federal District of Columbia. Okay, with me? We just get the facts? All right. The history of this case is, I don't want to say serendipitous, maybe that's too strong of a word, but there were some things that happened in this case that likely affected the outcome that could not have been understood at the beginning. When the case was first argued, Chief Justice Vinson was on the bench. Now, you probably don't know much about Fred Vinson. He was a Truman appointee. I think the only case of his you've read was that he wrote the dissent in Youngstown, right? You know, he was an okay Chief Justice, but he wasn't that influential. He's sort of been forgotten. I can't think of too many things he did that are worthwhile mentioning. When the case was first argued in 1953, the spring of 53, the justices couldn't reach an answer. Now, that's not exactly true. They could reach a decision, but it was not unanimous, right? There was probably 5 votes to rule that the segregation law was unconstitutional. But there was a strong desire to not have a 5-4 decision, maybe 6-3 or even 7-2. The people in the majority opinion wanted unanimous opinion. Okay, why do they want a unanimous opinion? They recognized this would be an unpopular decision in huge portions of the country, right? They realized that huge chunks of the nation would not accept this judgment. And the thinking was this: if it's unanimous, at least we can say that all the justices, liberal, conservative, from the North and the South, agreed, right? If there's dissent, they say, no, we agree with the dissenter, right? We think the dissent's right, the majority got it wrong. We'll appoint another justice and overrule it. We see this today, right? So there was a strong desire to make it unanimous. So here's what happened. They put the case back on the docket. And they decided to rehear it in the fall of 1953. Then circumstances changed. Chief Justice Vinson died in September 53. The Supreme Court's term begins in October. So basically 1 month before the term began, we had now a vacancy of the Chief Justice, which is very rare, right? Very rare. So President Eisenhower had a choice. He needs to fill the position. And he used what's called a recess appointment, where the Senate is in recess, you can fill up the vacancy. And who did Eisenhower select? Eisenhower selected Earl Warren. Earl Warren was the governor of California, also Republican. Earl Warren had presided over internment when the Japanese were being rounded up in his own state. He wasn't known as a liberal. He was known as a Republican conservative. Indeed, he was actually someone perhaps who wanted to run for president one day and may have challenged Eisenhower. There's some evidence that Eisenhower picked Warren to keep him out of the White House. Genius, right? But that's what history goes. Eisenhower again had Warren had very strong political instincts. He was very prudent politically. He was savvy. And he set out to make the judgment in Brown unanimous. That was his goal. He wanted 9-0 opinion, all the justices to agree. But there's a cost to achieving unanimity, right? What's the cost? Well, think of it this way, right? You write the draft of the opinion, and then someone says, well, you know what? I don't like that part. Can you cut this out? And I don't like that part. Can you cut it out? And well, maybe change this a little bit, and then I'll join you. Oh, you can't have that, right? You see what happens, right? If everyone gets their say on what gets in and what gets out, the opinion starts becoming a little bit more shorter, right? It doesn't say as much, because the more you say, you may alienate one of the colleagues on your court. When you read the Brown decision, you have to read it in that context. This was not meant to be a definitive statement of the 14th Amendment. It was not meant to resolve the segregation question in its entirety. It wasn't even designed to overrule Plessy. It did not do that. It was as narrow as humanly possible to decide as little as possible. Why? So they don't fracture off and get 5-4, right? They wanted 9-0, 9-0. And you have to read Brown in that context. And thinking was, let's just decide this now, and we can pick up the pieces later, right? There'll be time down the road if we need to make modifications, but let's just get this opinion out now, and we'll figure it out another time. Okay. Questions so far? All right. Let's start with the actual case itself. Where am I? Who am I up to? Vanessa, you next? And is Caitlin after you?
Pardon me?
Is Caitlin next? Okay, thank you. All right, Vanessa, thank you for volunteering. Begrudgingly, perhaps. The first issue that the court confronts is history, right? And they ask for some briefing on history. They ask, how would the framers of the 14th Amendment have contemplated, right, the issue of segregation, right, in schools? What would they have thought about that issue? How does that sort of inquiry turn out for the court?
They decided that like the historical part of the issue wasn't
What's the word they use? It's a weird word.
like inconclusive.
It's not very helpful, right? Yeah. Right? Yeah. It's basically, yeah, the sources cast some light, but they're inconclusive, right? It's not helpful. Now, Vanessa, what do you think the Kansas government would have said? Is the information there conclusive?
Yes.
In which direction?
For
Okay. So let me pause here. Thank you, Vanessa. The court requests briefing, right, on how the framers would have understood this and what did they intend. At the time that the 14th Amendment was ratified, the schools in the District of Columbia were in fact segregated. They were. They were segregated. When the court says the evidence is inconclusive, what they really mean is we don't like the evidence, right? We don't like where this evidence leads, because this evidence leads to a conclusion the opposite of what we're reaching. Okay, now I'm going to give a response to that in a minute, but I want to focus on this point now. This sort of argument in Brown is often used as a means to criticize originalism, the idea that you should follow the original meaning of the Constitution. And the argument goes like this. If originalism leads to segregation, if originalism leads to Brown being wrong, then originalism itself must be wrong. That you cannot adopt a theory of constitutional law in which Brown is wrong. That you cannot adopt a theory of constitutional law in which segregation is allowed. Right? That's a very common criticism of Brown, and one I'll respond to in a minute. And I think it's a powerful criticism, right? The court basically says, look, if we go history, those schools are still segregated. Now, I think there's a response that I find persuasive. Maybe you will, maybe you won't, I don't know. But there's quite a bit of historical evidence that the historical inquiry was wrong. Specifically, and I'll summarize it, there's a long reading, you don't have to read it, but there's a long reading in your casebook about the 14th Amendment. Shortly after the 14th Amendment was ratified, Congress passed a number of laws that guaranteed rights of education without regard to race. Right? That they legislated on this question, and they considered they considered education to be a privilege or immunity of citizenship, right? Which applies without regard to race. Right? Now, there's, again, considerable evidence that the framers actually would have understood segregation to be prohibited if you actually look at legislation passed shortly thereafter. The Brown court didn't consider that. They didn't have access to it. They just had a very narrow inquiry. Right? So I think on the merits, the evidence presented to the court was too limited. I think there was better evidence otherwise. But as a general matter, it's hard to argue for a theory in which Brown is wrong. I'm personally not troubled by it. There are lots of things about the Constitution I don't particularly like, and they lead to very bad results, and the answer is to change them. Just because just because people who enacted a provision didn't quite understand what they were doing, doesn't mean later on you can perhaps change and do something different. Okay, but that's not where I'm going with right now. Just I want you to understand this sort of debate about how Brown is used for argumentation. That if your theory means Brown's wrong, then you're wrong, right? Because Brown can't be wrong. In fact, it's become a current line of questioning for judges who want to be confirmed. And they always ask the nominee, was Brown correctly decided? And it's a bit of a trap because the follow-up question is, well, was Roe v. Wade correctly decided? Right? If you answer yes on Brown, what about Roe? So a lot of people judges say, well, I can't answer the question because I don't want to talk about abortion, right? But now they say, well, of course Brown's correct, but I don't want to talk about Roe. That's the new party line answer. Okay. All right. Thank you, Vanessa. All right. Any questions on that? All right. So the court here says that history is not helpful. So instead of relying on history, Caitlin, what does the court base its conclusion on? Has the court reached its conclusion if it's not relying on the history of the 14th Amendment?
Looked at separate but equal.
Okay, so talk about that for a minute, right? What do they say about separate but equal?
They agree that, the segregation was not separate but equal because to separate the young kids from white kids generates a feeling of inferiority, and it would have a detrimental effect upon them. And then they also agree that education is like one of the most important functions of state and local government.
Okay, very good, very good. The court, how do we describe this? The court's analysis here has a Brandeis brief feel to it, right? Remember the Brandeis brief in Muller versus Oregon? It argued that we need to have a separate hour law for women because women were inferior. And we know this because social science tells us. The court here follows a similar framework. They say, look, law isn't going to give us the answer here, right? Law won't tell us whether this law is just or not. In fact, they don't really talk about the sort of evils of segregation that you might think, that you're probably expecting. Instead, the case turns almost entirely on the importance of education, right? And why education is so important. That children can't succeed in life without education, right? That education is the foundation of good citizenship. And then they get to this sort of psychology stuff. They say that separating students because of race generates feelings of inferiority and may affect their hearts and minds. It's detrimental to children, right? Again, all these things, very well may be true, but this is not what you're expecting to say. That this is an awful form of segregation. And they get to this sentence where they say, whatever may have been the extent of psychological knowledge at the time of Plessy, this finding is amply supported by modern authority. In other words, Plessy may have been correct at the time it was decided. They're not even acknowledging that it might be wrong at the time, but we know better now. And they have this footnote 11, which is in the opinion, which is all the sort of social science, right? These sort of reports and studies. One of the most famous of the studies they cite was something called the doll test, which I think I have a picture of up here. What was the doll test? Yeah, where is it? There it is. So the doll test worked like this. They would give African-American kids two dolls, a choice. One doll is white and one doll is black. And they say which one would they pick up. And the thinking was that those who attended segregated schools were more likely to think that the white doll was better, right? They were taught about inferiority. Now, in hindsight, this study was not very accurate. There was no control group. It didn't follow any sort of methodology I think of today. So the entire basis of the study, may sound good, but it wasn't a very good state to work with. But the court finds this study persuasive. They say, any language in Plessy versus Ferguson contrary to this finding is rejected. Does this court overrule Plessy? No, at least not yet. It's limited to the narrow context of public education. And they say, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, the plaintiffs here are deprived of the equal protection of the laws guaranteed by the 14th Amendment of the Constitution. And that's it. It's a short excerpt, but the opinion is not very long. And the reason why the opinion is so short is because they couldn't get 9 votes for anything more, right? They couldn't say Plessy was wrong altogether. They didn't have the votes to say that segregation is evil. Because had they said that, that would have meant all forms of segregation have to stop immediately, right? The court didn't even hold that segregation must halt immediately in those schools. They did something a little bit more gradual. Have you ever seen a constitutional decision that says, we find this unconstitutional, so take your time fixing it? You ever seen a case like that in your studies so far? I haven't. I've been teaching this class for a number of years. Like, we think this is really bad, but take your time, right? We'll let you figure it out of how to go into effect. Okay, again, this was done because they recognized they could not get an order saying desegregate immediately. Perhaps some practical reasons. So then we get to the section of the opinion I call okay, so now what, right? Now what are you going to do about it? Okay, there's no order to shut down the segregated schools immediately. Instead, the court recognizes there's considerable complexity. These are complex issues. Now, just put aside the racism for a minute. Just put that aside for a minute. You have logistical problems. Buildings have to be constructed, right? School bus routes have to be changed. Teachers have to be hired, right? There are actual things that have to be done to allow this to happen. Now, maybe that takes a couple of years, whatever that. And there are some logistical issues, but the court recognizes that's not what's going to hold things up. Right? What will hold things up is the actual racism behind these policies. So what the court says is, let's re-argue the case another time, a third time. There's a third round of arguments. And come back later and brief some questions, right? Tell us, what should we do? Should the Supreme Court monitor the situation? Should the lower courts keep tabs on these schools? Right? And the Attorney General, you can file a brief, and anyone else files a brief you can. And that's it. Right? That's it. Again, it's this decision which you were all taught was like the most important case ever, and you get to the end, it's like, wait a minute, where's the rest of it, right? What happens next? Like, it's okay, come back later. And again, this was an iconic case that had, that the Warren Court just sort of said, we'll come back to this later. Okay. We'll get to Bolling in a minute. Any questions on the actual Brown decision? Again, it's short. It's probably not what you were expecting when you heard about it, but it's there. Loving, when you read Loving, I think Loving is a sort of opinion you expected in Brown, right? Where it's just this flat-out denouncement of white supremacism. That's the sort of language that you were probably expecting in Brown, but you didn't get there. Loving would happen, I think, 13 or 14 years later, a very different time. But the sort of strong opposition to the racism that you see in Loving, that's sort of what you expected in Brown. At least I did. Okay. All right, so let's go on to Bolling. Nancy, let me ask you this question, please. When we have Brown is considering whether the state governments are violating the Equal Protection Clause of the 14th Amendment. What's the difficulty in Bolling versus Sharpe? Why does that case present more of a problem for the court than does Brown?
Because they focus on the Fifth Amendment, where the racial segregation was affected federally, not the state.
Okay, very good. And one more question, if I can. Does the Fifth Amendment have an Equal Protection Clause?
No.
It does not. Right, so here we have our text of the Constitution. The 14th Amendment has a clause that says the states cannot deprive people of the equal protection of the laws. Okay. The court says separate but equal in education deprives you of the equal protection of the laws. Okay, straightforward enough. Then we have Bolling, right? This was, again, was a student attending a segregated high school in the Federal District of Columbia. The Fifth Amendment was ratified in 1791, long before Civil War. The Fifth Amendment does not have an equal protection clause. It does have a due process clause, which says that no person shall be deprived of life, liberty, or property without due process of law. Now, what did we just learn about with Caroline Products and Lee Optical? We learned that the court did not like the due process clause. We learned that the court was not willing to use the due process clause to halt state laws, that they were out of this business, right? That they were not going to be in the business of using the due process clause like the Lochner Court to say that laws are unreasonable. There was an exception, of course, which was Caroline Products, right? Footnote 4. And footnote 4 said that in some cases when laws impact the discrete and insular minorities, that heightened scrutiny may be warranted. Nancy, is footnote 4 cited in Bolling versus Sharpe? Do you remember? No. Surprised by that? I mean, wouldn't that be a good case to cite? You have this footnote, this famous footnote that says, you know, when you have these laws affecting minorities, you can a little bit higher review. It's not mentioned. I think the reason why is that the New Deal justices, the Roosevelt appointees, were still afraid of using the due process clause. Like they don't want to go down the road because they're afraid of Lochnerism. They'd get over that real quick in a few years, but at least in '54 they didn't want to go down that road. So instead of using the due process clause in sort of Lochner sense, Nick, how does the court explain itself, right? How does the court go about deciding Bolling, which was, again, a federal case, not a state case?
You kind of say that if the government's going to take away liberties, they have to have a proper governmental objective.
Okay.
And that's segregation. In this case, with the children go to school, which is no reason, it's not reasonably related to any proper governmental objective.
So it's an arbitrary deprivation of liberty.
Seems like it, yeah.
How is this different than Lochnerism? And Lochner, the boogeyman, right?
Not sure.
Well, Nick, does the government say, or Nick, let me ask you this question as a follow-up. Would it make sense to the majority that Kansas can't segregate schools, but D.C. can? Would that make sense?
Oh, no, yeah. They made that comparison if they were going to uphold the 14th Amendment in the state, that it just made no sense to
Yeah.
store it in the
Okay, yeah, okay. So as a threshold matter, the court says, this doesn't make any sense. How can it be that Kansas must integrate their schools, but the nation's capital, right, Washington, D.C., can segregate? How can that possibly be the right answer? And I think there's some rhetorical force to that answer. It does make sense. Maybe one response is those who framed the 14th Amendment were not worried about themselves, right? They were worried about the states. It was the states who were engaging in segregation. But let's just even take the argument its own face. The court makes a different textual argument, though. They develop a concept known as reverse incorporation. Reverse incorporation. Well, what's incorporation? We've explained incorporation like this, that the word liberty in the 14th Amendment incorporates provisions of the Bill of Rights. That is, the states cannot deprive a person of the freedom of speech. The states cannot deprive a person of the free exercise of religion, right? These provisions are fundamental liberties, and the state cannot deprive you of these freedoms. Reverse incorporation goes the other way. Follow me here. That the equal protection of the laws is incorporated back into the phrase liberty of the Fifth Amendment. I'll do it one more time. That the phrase equal protection of the laws is incorporated back to the word liberty in the Fifth Amendment. That is, it's reverse incorporated. In other words, by ratifying the 14th Amendment, now the federal government is also bound by the Equal Protection Clause. Is there any evidence this is accurate? None. This is gibberish. I'll defend Bolling in a minute. I think there's a better answer to defend Bolling. But this is absolute gibberish. This is, in fact, one of the reasons why people criticize, in general, textualism and originalism, because they say it's insane that Congress can still segregate their schools, so the text of the Constitution doesn't really matter. Let's do this because it's the right thing to do. You know, this opinion, Bolling, makes sense of things even though it ignores the text of the Constitution. Now, I'll defend Bolling in a minute, but I want you all to understand why the court did what they did. Okay, any questions on this? Okay. Now, I don't think Bolling is wrong. I think Bolling can be defended on textualist grounds. It's also premised, again, that privileges or immunities, right? If education is, in fact, a privilege of citizenship, then neither the state nor the federal government can deprive you of that right. So I think there's actually a decent textual argument based on the privileges or immunities clause rather than the equal protection due process clauses. But, you know, what do I know? If you want, there's a long excerpt in your casebook on a article by Michael McConnell, who was a law professor, became a judge, but I think it's quite persuasive. And then we have a response from Michael Klarman, who thinks McConnell's full of it, and you can read that also to get your own perspective, but I'll leave it to you to go on. Okay. Questions, anyone on Bolling? Questions on Bolling v. Sharpe? Yes, sir.
I'm kind of confused about the reincorporation.
I'm sorry, the reverse incorporation?
Yeah.
Yeah.
You're saying the court did not use that?
They did.
Oh, they did. Okay.
That's what they used. I don't think they used that phrase, but that's how it's referred to today.
Okay.
So today, whenever you have a federal case involving racial discrimination, it's actually a reverse incorporation case. That is, the court, I'll give you an example. We'll do a case later this term called the United States against Windsor. Windsor found that the Federal Defense of Marriage Act was unconstitutional. And Justice Kennedy's opinion explained that this is both a due process case and equal protection case by virtue of reverse incorporation. It's sort of strange, but the court doesn't. No one complains about it except for Justices Scalia and Thomas. Okay, any questions on Brown or Bolling? Yes, sir.
So it seems like the theme in regards to originalism is you agree with the holding, you just disagree with the reasoning.
Yes.
Like how the court came to it.
Yeah.
And that seems to be like the biggest critique on originalism.
There are a lot of critiques of originalism. One of them is, if Brown is right, then originalism must be wrong. Originalists will today say that Brown reached the right result, but for very different reasons. That in other words, the sort of social science reasoning in Brown was gibberish, and that there actually are historical evidence of why segregation in schooling violated the Privileges and Immunities Clause. Make sense?
Yeah, so then it would be that an originalist is more in favor of making amendments rather than doing this type of like reverse incorporation.
Well, in this case, I think originalists, and I speak somewhat personally, would argue that you would not need an amendment. But as a general matter, amendments are always better than judicial updating because the amendment has the legitimacy of the people ratifying it rather than having 5 judges on the Supreme Court reaching that conclusion, or in this case, 9.
Why is it so rare?
What's so rare?
Amendments.
It's hard, right? To amend the Constitution, you need 2/3 of Congress and 3/4 of the states, and it takes a lot of time. I'll actually answer your question a different way. One of the reasons why we've had so few amendments is that the Supreme Court has largely updated the document on its own. And a lot of modern things that people might like or desire, the court created by judicial fiat. So there's no need to amend the Constitution. For example, imagine we had a case in gay marriage, right? Imagine the court went 5-4 the other way and said that there's no right to same-sex marriage. Maybe there would have been a constitutional amendment to guarantee a right of same-sex marriage nationwide. But you don't need that because the Supreme Court made the decision. Right? Let's say the Supreme Court said there's no right to abortion. And people said, well, we want abortions. They can amend the Constitution to guarantee abortions, right? By reaching these 5-4 decisions, the court supplants the need to have the amendment process. I'll give you a more recent example. Citizens United was an unpopular decision about campaign finance. It was 5-4. In 2016, one of the candidates ran on the platform of overruling Citizens United. She didn't need to. Appoint one more justice who reverses it. Much easier, right? It's a lot easier to appoint a 5th justice than to reverse a case, right? People don't like the Second Amendment, perhaps. They don't like Heller. It's a lot easier to appoint one justice to reverse it than to amend the Constitution to give the right to bear arms, right? Having a 5th vote is much more valuable than having 3/4 of the people agree to amend the Constitution. And that is in part why we've had so few amendments to the Constitution. Make sense? Yeah, I think Opos was your hand up?
Oh, yeah, I was wondering about how the court implemented Worley.
Implemented what? Buchanan v. Worley you're asking about?
So that case was the right to choose who you can sell the
That's
property
right.
to. But in this case, students, they aren't leases.
Yeah.
They're probably maybe at most licensees because they aren't entities, they're not paying for education. How did the court actually fit that in? I agree with the principle, but I don't agree how the analysis.
Well, are you saying how did the court actually ensure that schools were integrated? Is that your question?
Yeah, because to convey property to a student,
Oh, I see what you're saying.
Well,
there's not really any property being conveyed. I think, I think public education is not a property interest, right? It's not something you can sell or inherit. I think a public education is basically I don't think it's a right. I think it's a privilege, but it's a privileged immunity. So it's something that the government owes to people to a certain degree. Does that make sense? Yeah, I think your first question was a good one. Did the city of Louisville stop enforcing their segregation law? Actually, I don't know the answer. I don't know if Buchanan and Worley ever actually sold their property to each other. I have no idea. I'll have to check on that later. But I think the question of how to carry this judgment to execution is very tough. And if I can move it to Brown 2, that makes sense? Okay. Anyone else on Brown 1 before we move to Brown number 2? Okay. Everyone knows about Brown versus Board of Education number 1. Most people don't know about Brown number 2. In fact, I don't think Randy had this case in the prior edition of his casebook. I think I asked him to add it, and he agreed. Brown number 2 was decided about a year later. And this was a sort of a strange case, right? It's basically saying, okay, we made our ruling. Now what are we going to do about it, right? What's going to actually be the order that comes in? Jonathan, I think you're next. You want to walk me through Brown number 2, please?
Yeah, so basically this was after, obviously, the decision of Brown 1. And then a few of the states weren't exactly implementing the non-segregation schools, and so they were looking at enforcing them, making them, turning into a speedier process.
I'm sorry, say it again?
Turning it into a speedier process to
Okay.
desegregating.
Yeah. And who would be running the show? Who would actually be monitoring the local situations?
Wouldn't the attorney generals?
No. Who's actually keeping the local governments in check? Is it the Supreme Court?
No.
Who is it?
The state courts.
Not the state courts.
The district court.
Yes, the federal trial courts, federal district courts. That's exactly right. The court says this is a complex problem, and you need local solutions, right? And it'll go like this. First, the schools decide how they're going to handle the issue of integration. And then the local courts, the district courts, can decide if those actions are good faith efforts to comply with Brown. Courts that are closest to the conditions can best perform this judicial role. So the Supreme Court remands to those courts. This case effectively put every school district in the United States, every segregated school district at least, under federal supervision. And then the court gives some guidance, right? This is not, okay, we made a ruling, do it immediately. They say courts must have flexibility to shape remedies, right? You have to adjust facilities and take into interest public interest. But the court then says an important statement. They say, the vitality of these constitutional principles cannot be allowed to yield simply because of disagreement. What are they saying? If there are legitimate reasons why you can't integrate, tell those to the court. But if you're just dragging your feet and creating delays because you don't want to do it, that's not going to work. The court says that a prompt and reasonable start is essential. And then after they make a start, courts can give more time. Right? You have issues of physical condition of the schools, school transportation, the school bus, personnel, regulations, laws. Things will take time. And during that period, the court retains jurisdiction. And then the court puts a sentence at the very end. They say that the schools must integrate with all deliberate speed. It's a very important phrase, which you'll hear a lot. With all deliberate speed, the very last sentence of the opinion, or at the very end. Dylan, what does this phrase mean? All deliberate speed. What does that phrase mean, sir?
Sorry, what part was it in?
All deliberate speed. What does that phrase mean?
Just do it quickly.
I don't know what what does that phrase mean? All deliberate speed. You're asking way too many follows for a three sentence word phrase. This is not a hard question.
So no, sorry, I was just kind of.
What does the phrase all deliberate speed mean? It's 3 words, 4 words. It's 4 words. What does the phrase mean? All deliberate speed. What does that mean? Mitchell, what does that phrase mean?
They have to intentionally move the process forward.
What's the word deliberate add to that?
Deliberate means like their purpose and intent.
Yeah, it's a question of intent and what's their purpose, right? The court is not establishing an arbitrary deadline. You know, you must integrate within 18 months, 24 months, right? 36 months, whatever the number is. They say all deliberate speed because they recognize that there's not going to be a one-size-fits-all solution, that every district might have different situations, that there might be some districts that move quicker than others. Okay? Now, would it surprise you if I told you that we're now in the year 2019? We're now, oh my God, I guess 65 years since Brown, if my math is right. There are still school districts today. Still school districts today in the year 2019 that are under supervision by the courts. Still, today. 65 years later, right? The initial kids who are going to, I think Lyndon Brown died a few years ago, if I remember that right. But the initial kids who are at this case, they're senior citizens. And the school districts are still under supervision. So this phrase deliberate speed might have sounded, smooth in the 50s, right? But decades later, it's not sounding so deliberate. It's not sounding so speedy, right? It's sounding pretty slow. Okay, but again, I'll come back to you, Dylan. Why do you think the court added this phrase, all deliberate speed? Why did they choose this language?
I guess because different areas would go forward at different paces.
And what did the court expect to happen?
is that I think that they expected certain areas not to comply.
Okay, I think that's right. They thought there was going to be some, how I put this, foot dragging, right? I'll put that mildly, right? They expected that there were some districts that would drag their feet and stretch this process out. What they did not expect was what happened in Little Rock, Arkansas. They did not think that was going to happen. Right? They did not expect the so-called massive resistance that popped up in the wake of Brown. They didn't expect that, right? That was something that they underestimated the resistance. You know, we always ask in this class, why do people follow court decisions? Chief Justice Warren probably thought, okay, we'll make our ruling, give them some space, they'll come around. Not quite, right? The next case we have is a case that is very significant, and it's not well understood either. And the name of the case is Cooper against, oops, oh, damn it. Sorry. Cooper against Aaron. I want to play a little bit of the video from this one. I usually don't like playing my own videos in class. It's kind of weird. It is, hearing myself while I'm standing here. But I think the video in this case is sort of important because it demonstrates it. So we're going to start playing.
I got a quick question.
Oh yeah, go ahead, Josh, please. I'm sorry to interrupt.
Before we move on,
Yeah.
It was out of curiosity pretty much, but when you mentioned like some of the schools still under the supervision of those courts,
Yeah.
could you just expand a tad on like in what ways are they still under the supervision of these?
Okay. Primarily in states close to us, Louisiana and Mississippi. I don't have other states, but I know at least Louisiana and Mississippi have some. The schools don't have segregation policies, right? It's not, they say, okay, if you're a black student, you go here. If you're a white student, you go here. But often schools might adopt policies that have the effect of admitting predominantly one race over the other. And this could mean through how they draw the zones for schools. This could mean how they establish admissions policies. And many courts have retained jurisdiction to see, are they actually trying to implement integration, or are they keeping these policies that keep the schools de facto segregated? That is, even though there's no segregation policy, a huge percentage of the kids might still be white in one school and black in another. So those courts actually are still nudging the school districts to adopt policies to break down racial barriers. Right, so the nature of the segregation is not the same as it was in the 50s.
Like an underlying.
Yeah, it's the difference between, let me explain it to you this way. Is there intentional policy that, segregation? No. But do the policies adopt to the effect of separating kids? Maybe. And that's what the courts are going after. Does that make sense a little bit?
Yeah.
We'll do more of this when we talk about the affirmative action cases later this, I guess, next class. But so it's a different type. Yes, Rosh?
Isn't that also kind of what's happening with when you say these schools? That you have a mass exodus of predominantly white students and an influx of minority students?
Yeah, I don't know that that's new. I don't know if that's happening, but that's an issue. Yeah, there's one situation, I think it's in Louisiana, where there's basically a town near the capital, near Baton Rouge. And just Google this, I forget the name of the town, but basically a bunch of people formed their own township, right, to create their own school district. Because they were sick of the schools from the Baton Rouge government. And one of the arguments is this now be basically an entirely or almost entirely white school district, because people moving out were the more wealthy areas. So I'm sure there'll be some sort of legal challenge to whether this is consistent with school desegregation. What I'm getting at is the issues identified in Brown almost half a century ago haven't vanished. They sort of just changed form. Okay? Any other questions on Brown before I get to Cooper? All right, let me give you some of the background in Cooper. I will play some of the video. In Little Rock, Arkansas, I'm sorry, the Arkansas government was not party to Brown, right? They weren't involved in the case. I think they filed an amicus brief, but they weren't a party. After Brown was decided, there was actually some positive steps where the school board began taking some initiatives to integrate. But then a movement arose, which was called the Massive Resistance. The Massive Resistance was exactly what it sounded like. They wanted to resist Brown and integration. And a group sprung up called the White Citizens Council, which established these chapters throughout the South to oppose Brown. Now, I had a student in the past, and she told me this. She didn't quite appreciate it, but her mom grew up, I think, in Mississippi, and she always said her mom went to a council school. A council school. She knew what that was. I told her what that was. The White Citizens Council opened up white-only schools in Southern Mississippi. Just Google this, Mississippi Council Schools. It's there. And I told this girl that she was like, she had this look on her face. Her mom was in fourth, fifth grade, just had no idea what was going on, right? She just didn't know. But they basically built up separate schools so their parents would not send their kids to public schools. All right? But things got very dangerous in Little Rock in this period because the governor of the state, his name was Orville Faubus, opposed integration. And he made this not just a legal issue, but a political one, because it was tied. He wanted to be reelected on the platform of keeping the schools segregated. So let me play a little bit of this video.
Order to block the state court injunction. The situation escalated quickly. Governor Orville Faubus ordered the Arkansas National Guard to prevent black students from entering Central High School.
Units of the National Guard have been and are now being mobilized with the mission to maintain or restore the peace and good order of this community.
The National Guard blocked 9 African American students, known as the Little Rock 9, from entering Central High School. Neither Faubus nor the Guard were bound by the previous court order. After a federal court enjoined the National Guard from blocking access for African American students, the Little Rock Police Department took their place. The police had not been included in the court order that bound the National Guard. 2 days later, in one of the more dramatic moments of the Civil Rights Movement, President Eisenhower dispatched the 101st Airborne in Arkansas.
My rule cannot be allowed to override the decisions of our courts.
These storied federal
Okay, put it over here.
The troops escorted the Little Rock 9 into Central High School.
By the way, if anyone ever goes to Little Rock, it's a museum now. The school. It's actually still a functioning public school, but it's also a national park. I felt like such a creep because I'm going to take a picture of this high school. I felt like a real creep, but for my students, I'll do it. It was a little creepy. I mean, they weren't like walk around, but it was like, okay, a little creepy. Okay, I'll play the video.
And a class under the supervision of federal troops. Study guide. What would have happened if President Eisenhower chose not to send in federal troops?
I'll stop it right there. Thank you. If you didn't watch the entire video, I encourage you to do it. Most of the videos are okay. I think this is one of our best videos in the entire library. Loving Alsting is probably our second best video in the entire library. The actual footage of the Lovings talking, I love that one. And this one, so you have the Eisenhower, but it's very dramatic. This case, Cooper, is so significant, right? Because it asks the question of what happens when people don't follow the court's orders. But I want to be very precise here. The Arkansas government was actually very careful. They didn't disobey any court orders. They didn't disobey the Supreme Court. It simply found very creative ways to avoid court orders. How? They said, well, you guys put an injunction against the National Guard, so we'll send the local police department, right? Oh, you join the police department, we send in the other, we send the mayor's guard, right? Every single time one group had an order against them, they just picked up another group to come in and keep these kids out of school. Okay? So they didn't actually disobey the court's order. What happened at the very end of the case, right, when the Supreme Court finally ruled against them? They just shut down the school, right? We'll do the case in a minute. I want to go through it in a bit. But what happened at the very end of the case? They just shut down the school altogether. There was an entire generation of people in Little Rock who did not have a high school diploma. They just never, they never graduated. There was I think a 2 or 3 year period where just the schools were closed. This is a picture of a school district in Virginia, I think in Prince Edward County of Virginia, where they also shut down the school districts. Now, some states got creative. It's okay, we will shut down the schools, but we'll give students vouchers, right? These little credits, which they can use at private schools, which are segregated. Right, the way that the Mississippi Council School operated was you basically had some state funding to keep alive these private schools. What happens when the court says integrate and you say, no, we're going to shut down our schools? At that point, the courts look pretty bad. There was one case in particular called Palmer versus Thompson, which involved a swimming pool, a public swimming pool in Jackson. I think it was in Jackson, somewhere in Mississippi. I think it was Jackson. The court ordered you must integrate the swimming pool in Mississippi. What did the government do? They filled it with cement. They just closed the pool altogether. Rather than comport with the court's order, they just shut down the pool and they filled it up with cement so no one could swim. And you're laughing. But that was their decision. From Beverly Hillbillies, a cement pond. It was literally a cement pond. They filled it up rather than allowing the students into the function. Right? This is what the massive resistance was about. They avoided directly ignoring the court order, but they found very creative ways of evading them. And the source of authority they had is a strange one, which is Abraham Lincoln. Right? This is sort of the Lincoln argument. Dred Scott was a conflict between Dred Scott and Sanford. It did not involve anyone else, so therefore we don't have to follow it. And they took this to a frickin' extreme, right? They took it all the way to the edge where, well, you sued the National Guard, but you didn't sue the mayor, you didn't sue the governor, you didn't sue the police department, right? They kept sort of moving the goalposts at every juncture. And this went on for years until finally you had shutdown where they would just close the district school altogether. And the Supreme Court would not get back involved for years. So again, you have this Brown decision, which like this huge victory, this moral clarion of righteousness, and then you have Cooper. It's like, whoa, what the hell's going on? And then silence, right? Just you don't have anything for years. What would actually integrate the schools was not the Supreme Court by itself, but it was the political process working together, right? I think Amy, I think you're next. What would have happened if President Eisenhower did not send in the federal troops after the district court order? Just to be clear, Eisenhower sent in the troops before the case got to the Supreme Court. The case got to the Supreme Court later. People always confuse the sequence, think, oh, Eisenhower sent in the troops to enforce Justice Warren. No, that's not what happened, right? Eisenhower sent in the troops from the district court order. But Amy, let me ask you this question. What would have happened if Eisenhower decided to not send in troops? And let me add one more point. Eisenhower disagreed with Brown. Eisenhower hated Earl Warren. He said Brown was wrong. He said this privately, not publicly, but he said privately, I did not like Brown. The court should not be involved with this. Or finally get your question, Amy. I've been dancing on it for 5 minutes. What would have happened if Eisenhower didn't send in the troops?
I'm not sure. I think all the courts would have had their hands tied and not really have another way to implement their decision.
Yes, I mean, this is you've seen this photo before. This is an iconic picture. Again, I walked up those steps. Again, I felt like it's a little creeper, but I walked up the steps, and it's it's a pretty intense situation. It's a huge building, by the way. Like, thousands of students. I think 3,000 students go there. But you say their hands would have been tied. What does that mean practically, that their hands were tied?
Like the courts have made their decision and done their part, so all they can do is start, I don't know, I guess, try to throw them in jail.
Okay, and who's going to go arrest them? Is Justice Warren going to come down there with his gavel and start beating people up?
Yeah, no, they wouldn't really do anything.
Think, what does this remind you of? What case? Where you say go arrest them and they can't arrest them. What case does this remind you of? Yeah.
General.
Yeah, what was the name of that case? Remember? Good review. Anyone? Name? Yeah. Merriman. Very good. Thank you, Caroline. Ex parte Merriman. All right. If you recall, Chief Justice Taney found that Lincoln had, or the General Cadwalder had improperly held Merriman without giving him a hearing. And then the general didn't show up for the proceeding. And then, poor Taney goes to his marshal and says, hey, go arrest the general of the Union Army. Knock, knock, who's there? I'm arresting you. Good luck with that, right? But there's a certain sadness, or almost maybe pathetic aspect of this, right? The court issues a ruling and like, okay, that's nice. You've made your ruling, go enforce it. And the Little Rock case comes very close to that. I don't think it's direct defiance of the district court's order, but it's close. And had the president of the United States not gotten involved, I don't know what would have happened. I don't have an answer. I think about this question every year candidly, and I don't know what would happen. I think if Eisenhower said, not my problem, not going to deal with it, I think at that point, every single southern state would have followed the same blueprint and denied access to the children to go into their schools. I don't know what would have happened. You had a 9-0 decision that was basically being thumbed at. It would have been, I think it would have been very bad for the courts. I think Justice Warren would have been embarrassed and humiliated. And I think he would have not been able to do the sorts of things that he wanted to do in the court. You want to add anything? It's sort of like this, this thought experiment. What would have happened? Yeah, Nick?
Chronologically, if, like this picture, all this happened before the decision, that quote that he has about the mob mentality overriding the court's decision, it kind of doesn't feel as appropriate. Unless, like, he's referring to Brown.
I'm sorry, which quote are you talking about, Nick?
Where he's,
who's he?
Eisenhower,
yeah.
Along the lines of the mob mentality overrides the court's decision.
Well, even before this picture, right? You had this picture.
Yeah, that it was just on the screen.
Right. I mean, you had this scene, right, where you had basically federal troops standing outside the. You had federal troops saying, this was the mob he was talking about, right? That you have state officials denying entry to these students. And, this is, I think Eisenhower just did not want this going on in his country. He didn't much care for the Supreme Court, but he didn't like the idea that you had these armed officials keeping kids out of school. I think that was a bridge too far for him. Yes?
He was the president who actually appointed the judge.
He did.
So
he did. Oh, so you think Eisenhower had an obligation to follow Warren because he appointed him? Is that what you're saying? Let me tell you something. Eisenhower hated Warren, right? In fact, one of the reasons why he put him in the course to get him out of politics, he was afraid of him running against him. In fact, Eisenhower said, the biggest mistake I made as president was appointing Earl Warren. He said, the biggest mistake he made, we all make mistakes, right? The biggest mistake he made was appointing Earl Warren. Yeah, it's good. I don't think, and let me respond to your question this way, Angela. He wasn't following Warren. I think he was afraid that the district court was being ignored, the trial court. If you actually look at Eisenhower's statement, he doesn't actually say the Supreme Court. He says the federal courts. He was actually very careful about that because he's talking about the lower court ruling. I think the courts in general, right? He believed in the rule of law, and he didn't want the courts being ignored. I think that's the short answer. I think that's about right. Anyone else want to add anything on the Eisenhower question? Okay, I'm going to pause this so I'm not just running in the background. Okay. Okay. Yeah, go ahead, please.
If they would have allowed them to violate the rights of the African American people, then that would have opened up the door for them to actually violate like everybody.
Yeah.
To the 14th Amendment, because it was for everybody.
You know, at this point, the 14th Amendment didn't really mean much, right? You had privileges, immunities were dead, due process was dead, equal protection might have been dead also, right? I think had the Brown decision been just flouted, I think the courts would have had no role in the civil rights movement. I think it's up to the political process altogether. I don't think the courts would have had decisions that they did. Okay. All right. Let's go back to the actual facts of this case, right? After Eisenhower sent in the troops into Little Rock, the Little Rock School Board said, we have a problem, right? We can't have federal troops in a building. It's very disruptive to learning. In fact, the Little Rock 9 had to spend their school day in the principal's office because they didn't want to be killed. They didn't want to be beaten up, right? They were not able to learn. They caused such a threat to their safety that they couldn't even leave the principal's office. And so the school board says, look, we need more time, right? We can't have a school day with federal troops walking around the building. It's just not feasible. Okay, so what happens next? The school board asks for an extension, right? They ask, I think, for a 30-month extension to the court and say, look, we need basically 3 years, or I guess 2.5, right? We need another couple years to figure this out. We can't deal with this right now. We need more time. You know, we don't know what will happen in 2 years, but we need more time. And then the district court surprises everyone and says, okay, you know what? I agree. Again, this was a judge who was in Little Rock who recognized the sort of insane stuff going on by the school, and it's like, okay, take a break, you get 30 months. At that point, the NAACP appeals to the Court of Appeals. And they tell the Court of Appeals that this 30-month extension is not consistent with Brown. That Brown required integration with all deliberate speed, and that this is a delay, you're dragging your feet, just do it, go ahead with it. We need it for the next school year. This happens, I think, in June or July. School begins, right, beginning of September. The case is then appealed to the Supreme Court on an emergency basis. Usually, the Supreme Court takes 2 or 3 years to hear a case. It takes a while. This case was appealed up in a couple months. And they heard arguments over the summer, which they never do. They usually don't hear arguments over the summer. They heard arguments in August and then again in September. All right. One day after the case is argued, the court issues a short decision, what's called per curiam, basically an unsigned opinion. P-E-R-C-U-R-I-A-M, per curiam. And they say that we affirm the Eighth Circuit Court of Appeals, and we agree that this 30-month extension was improper, right? Therefore, that the school must open up, integrated. The school is supposed to open September 15th. You get an order September 12th, right? Again, one more time. You get an order September 12th, school's open up September 15th. Do you think there's any chance the school is actually going to open up integrated? Not a chance. So I'm going to cut to the end now. I'll come back to the details in a minute. But Orville Faubus had a bill that had been passed by the legislature. Right? What did the bill do? It allowed to transfer all the public schools to private groups. Why did they do this? because private groups were not bound by the 14th Amendment. So as soon as this decision came out from the court, he signed the bill. Schools would not open up integrated. They would close for some time. So the effect of the decision on September 12th is almost meaningless, right? Nothing actually changed on the ground. A couple weeks later, the court releases the opinion that's in your book, right? This opinion was unique in that it was signed by all 9 justices. I want to just explain that. You have a unanimous opinion all the time, right? It's a 9-0 opinion. But usually it's one justice writes it and the others join him. That's usually what you see. This was different. This was a case where all 9 justices signed it. Why did they do this? They wanted to show that there was complete unanimity, that a couple years had passed since Brown. There were now new people on the court who hadn't been there before, and they wanted to illustrate that we are all on the same page. We all agree with this decision. Justice Brennan was the lead draftsman of the opinion, and he was very good at incorporating edits from everyone and keeping everyone on track. I wrote a paper on this exact case, and I went to the Supreme Court archives, and I pulled all the draft opinions, all the notes, all the letters, and they were fighting back and forth, but eventually they came to a single conclusion. Right? The narrow issue here was this. Was a 30-month extension reasonable under Brown? That's, I think, is an easy question. Probably not, right? I think it's an easy enough question. The court says that 30 months was not reasonable. Integrate immediately. But then we get to the sort of bigger picture. They say it's not enough to just decide if Brown was violated. We also have to consider whether the school district was running afoul of Brown, right? Whether they were ignoring our decision. And this is where I think the court has some difficulties. Brown did not involve Arkansas. Arkansas was not a party, so it wasn't bound. But Justice Brennan sketches a theory that is often called judicial supremacy. Judicial supremacy, although I have a different phrase, judicial universality, phrase I prefer. This is my own thing. And what Brennan argues is that when the Supreme Court issues a decision, that decision becomes the supreme law of the land. And all states are bound by that supreme law of the land. So even if Arkansas wasn't a party to Brown, the Supreme Court's decision was itself supreme. Now, was there precedent for this? I don't think there was. Marbury did not say this. The other cases cited didn't say this. But the court developed this concept that the Supreme Court has this monopoly in deciding what the Constitution is. And whatever other opinions they have becomes supreme law of the land. Right? Lincoln, Dred Scott, be damned. If Marshall is right, I'm sorry, if Marshall, if Cooper is correct, then Lincoln was wrong and Dred Scott was the supreme law of the land. If Cooper is correct, then Plessy was supreme law of the land. And in theory, the supreme law of the land can't be changed absent an amendment. So you can't overrule a Supreme Court decision if that's actually seriously. They don't mean that. They're not serious about that, but that's what it would mean. Now, it's one thing to say that Cooper was supreme law of the land, but was it actually supreme? Because again, immediately after the case, almost everyone started to ignore it. Right? School districts sold the schools, shut them down. And so when you have the court declaring itself supreme and everyone ignores it, what's the significance, right? You know, if a tree falls in the forest and there's no one there to hear it, does it make a sound? This sort of decision just did not have any salience. In the aftermath of Cooper, there was actually these billboards that popped up throughout the South that said, "Impeach Earl Warren," right? He was a very unpopular figure. He was a very unpopular figure. Okay. Yes, Braden.
Did any politicians run under that kind of banner of, if I get elected, I'll try to impeach Earl Warren?
Yeah.
Is that a pretty popular opinion?
Yeah, I mean, the politics in the 60s were a little bit different than they are today. But there was a political party known as the Dixiecrats, which basically the Democrats who were pro-segregation. And I think a lot of them favored impeaching Earl Warren and removing him from the bench. But yeah, it was pretty common. All right, questions on Cooper? Very important case. Very little about Brown. It's only a short paragraph. I think the important point is where they sort of make this broad ruling about their rulings being supreme, and then people sort of just ignore it. Yeah, Sergio.
Just going back to Josh's point about modern segregation, just defending the South a little bit. I was reading up, and it seems like New York is actually where segregation is actually the most prevalent.
I am from New York. Yeah. I grew up in Staten Island, which when I grew up it was predominantly white. Depending what neighborhood you live in, there is neighborhoods can be quite homogenous in New York. I'll put it that way. Yeah. Yeah. I mean, it's again. The modern form of segregation again is not deliberate, but by virtue of where people live and reside, it creates districts in which you have mostly people of one race versus another. It's not like a conscious effort. But we'll revisit this when we do affirmative action, the exact question. Yeah?
Even extending outside New York, I spent a lot of time outside New York City. There's a lot of redlining that was going on in the 90s.
You want to say what redlining is for everyone?
Redlining is it's an unofficial way that real estate agents, for example, would try to contain, in this case, black people to a particular neighborhood. In Buffalo, there's this one area called the Fruit Belt.
The Fruit Belt.
There's
Okay.
one particular side of the highway where in the 90s there was a lot of redlining, and it's still predominantly black.
Yeah. Yeah, it's not limited to the South, but the districts that are under federal supervision are there because of the aftermath of Brown. That's the point I was trying to make. But you're absolutely right. You have in New York City where I grew up these specialized high schools. Stuyvesant. I went to Staten Island Tech, which is now one of the top high schools in the country. Was not there when I was there. And admission to these schools is based entirely on these exams, which you take an exam. The schools are almost predominantly Asian. It's like 80, 70% Asian and 20, 30% white and like only a handful of Hispanics and African Americans. And there's a movement in New York to abolish the exam and use other means to admit the students to the school. I'm thinking that the exam disproportionately impacts certain racial minorities. This is a live issue in New York. In fact, the current chancellor of the New York City schools was formerly the Houston commissioner, a guy named Carranza. So that issue is still going on.
Isn't it not only the exam, but because in New York they have choice with where they want to go to high school?
Well,
so it's also an admissions criteria?
For the special high schools, the exam's what gets you in. Yeah, but you can if you pass the exam, you can go to that school. But generally, you have to go to your zone school, which is nearby. I was actually zoned for Staten Island Tech, or at least that was my zone school, but it was close enough. It's like 20 minutes away. Yeah, right.
Questions in this exam only have answers that white people and Asians would know?
I did not get good enough exam. I didn't score well enough in the exam, so I couldn't tell you. When I went to Staten Island Tech, it was based on grades, not exams. So I did not do well enough for Stuyvesant. It's a tough issue. The exams are not always measures of raw intelligence. In many regards, they're measures of how much you prepared for a certain exam. And the argument is that sometimes people with means have more abilities to prepare for the exams than others. Think like the SATs, right? If you look at any distribution for standardized exams, some racial groups do better than others. And it's not a measure of raw intelligence, but it's about preparation in many regards. Yeah, Sarosh.
California, they do the same thing but on income lines.
Well, in California, California has a law that prohibits racial affirmative action. It's against the law in California. So Californians use other means to get there, one of which is economic status, which is not always a good measure because, in that case, well-to-do minorities are not admitted. When you do the readings for Thursday with Fisher, it's an affirmative action case, The University of Texas said we don't only want, they said this in the record, we don't only want poor black people, we also want wealthy black people in our school. And they said we want the children of a wealthy doctor in Dallas. That was one of the examples they used. So in that case, the socioeconomic would not get you in.
So in that case, like he was mentioning up in New York, the exams to get in, or as the admission standard pretty much, what alternatives were being proposed, I guess? Like
so the alternative would be grades in the school in which you attend.
couldn't that also be the same argument against that? Like, okay, well, you're better prepared to do well in class. You have the means to prepare.
Well, yeah. Let me address this. You'll read about in the Fisher case Texas's alternative. For about 15 years in Texas, affirmative action was not permitted because of a circuit court decision. Instead, Texas developed what they call the top 10% plan, which now is like top 5%. It fluctuates every year. And the idea was if you graduate in a certain top X percent of your class, you're guaranteed admission into UT or A&M or one of the state schools. That sounds neutral, but it's not. And the reason why is because most schools in Texas are racially stratified. So in some schools it's predominantly African American, some Hispanics, and predominantly white. You're in the top 10% of your school based on who's around you. And if the students around you aren't quite as academically accomplished, you're more likely to bounce up. So Abigail Fisher was the plaintiff. She went to Sugar Land High School, which was a very good high school. She did not make the top 10%. Had she went to another high school, perhaps in a worse area, a less affluent area, she would have been in the top 10%. In fact, I'm told that people actually transfer in Texas their senior year to get a higher class rank. Is that still the case?
It's definitely done.
I didn't grow up here. I didn't know about this, but apparently people game the system. But they do that because it might be easier to get 10% if you transfer out. Is it your class rank upon graduation or all 4 years? Which one is it? I heard two things.
What's a cumulative?
Okay, whatever. People apparently transfer to get their admission to UT or A&M or whatever. People game it. But so what's the alternative? It would be your class rank, but class rank is basically geared based on the racial stratification of schools. So that would be one way of doing it. But the standardized test, as it's administered now, it's predominantly Asian and white, at least in New York. Yeah, I did not score well enough in the Stuyvesant test. I didn't study for it at all. I think I got a book like a week before the exam. I didn't really know what I was doing, but I did not score well enough for the Stuyvesant test. Stuyvesant at the time was like the top high school. Now, somehow Staten Island Tech, where I went, has gone higher. Mine was based on grades, but whatever. I did well. High school, right? Remember high school? Wasn't that long ago, right? Trying to forget it, maybe. High school. God. All right. Other questions on Cooper? All right, let's go on the last case, please. The last case is Loving versus Virginia. Did anyone see the movie Loving? Yeah, let me play a clip from it. It's a very good movie. I usually don't like court movies. They're usually all terrible. But this one's very good. This one, I'll play this scene. Okay. All right. So let's just start the facts. Are you next, Kyle? Oh, man.
All right. Two Virginia residents.
Whoa, look at no notes. That's ballsy. Good for you, man.
I've been needing to go for a while.
Okay, you know what? You go. I'll come back to you, okay?
No, I got it. Two Virginia residents. Mildred was African American. Richard was the white dude. They went to get married. They came back. They were in violation of two Virginia statutes.
That's
and there was a racial integrity act that said only white people could marry white people.
Yeah.
They came back. They got a grand jury indicted. They were sentenced to a year. The judge suspended it and said, "Get the hell out."
Yeah.
And they brought suit.
That was good. That was really good. That remember the best standing recitation I've ever gotten. That was really good. He's trying to ask you to stand, but man, that was on his feet. Very good. I got nothing else to say to that. That's right. All right. Thank you, sir. Okay. So Virginia had two laws in the books that are relevant here. The first one you've already studied. All right, the first one is called the Sterilization Act. And that was a law issued in Buck v. Bell. Right? And that law, members said that imbeciles could be sterilized. The second law was called the Racial Integrity Act. And they were enacted in the same package. And these are both aspects of racial eugenics, right? Again, what's racial eugenics? Preventing undesirable people from reproducing. So number one, you take imbeciles, you say you can't reproduce at all. Number two, you say you can't have interracial marriage because that was considered putting out undesirable people. Right? It was an idea from the exact same source of authority. So you had this Racial Integrity Act. So in Virginia, Mildred and Richard could not get married. Instead, they traveled across the river to the District of Columbia where they were married, and they came home. Okay? I want to play this clip from Loving also. There's a very video-heavy day. They were arrested then in the middle of the night. This is in their own words.
About 2 a.m. And I saw this light, you know, and I woke up and there was the policeman standing beside the bed. And he told us to get up, that we was under arrest.
They came one night and they knocked a couple times at her, and before I could get up, you know, they just broke the door and came in on it. When we got up there, standing beside the bed with flashlights.
Richard was released on bail, but Mildred was forced to spend the weekend alone in prison. At the time, she was pregnant.
Yeah, they deliberately arrest them on a Friday night, knowing that bail wouldn't be granted until Monday morning. Right? Usually, you have to be arraigned within 24 hours, with an exception for weekends. So she would basically spend the entire weekend in jail by herself, and she was pregnant at the time. They were charged with violating the Racial Integrity Act, and the trial judge, they were found guilty. They violated the law. They were sentenced to 25 years in prison. But the judge suspended the sentence. That is, said you don't have to go to jail if you leave Virginia and you don't come back for 25 years. At that point, they moved to D.C. and they were living their lives. And they didn't really like living in D.C. They wanted to go back to Virginia. They had a farm, different lifestyle. But at that point, they couldn't move back to D.C. I'm sorry, they couldn't move back to Virginia because that would be violating the state law and the court's order. So they had an idea to challenge their conviction. Now, you probably know this, but when you have a conviction, you have a certain amount of time to appeal, right? You have a certain amount of time to appeal. And if you don't appeal in a certain amount of time, your conviction becomes final, right? People who have been convicted of crimes can't go back and challenge it years later. You're not allowed to do this. So this is a scene I want to play you where the Lovings go to meet a lawyer, the NAACP, who gives them an idea of how to challenge their conviction. This scene is, funny is the wrong word, but just you watch this. I love this scene.
His name is Cole.
So this was a lawyer who came up to meet them in D.C. He was a Virginia lawyer.
Hello. I'm Bernard Cohen. I'm in from Richmond. I talked to Jim about using his office for a few hours.
Yes, Mr. Cohen, do you know him?
Down the hall. My clients are Mr. and Mrs. Loving. Could you send them down when they arrive?
So he's basically borrowing someone's office, trying to seem all important. Look what he does. I love it. It's a good lawyering scene. Taking all the family pictures. One day you'll do this, have a client come in. It's kind of cool. They got the likeness down pretty good also.
Mark Cohen. It's a pleasure.
Thank you for coming in today. So, as we discussed on the phone, the ACLU would like to take on your case. I was actually a charter member of the ACLU in Virginia, which is why they assigned me to you. The bottom line is, we want to get you all some relief.
That's very generous. Thank you.
Now, the first step is to appeal the sentence in Caroline County. That will be our fastest route to federal court. The problem, federal court? Yes, the goal is to try to get the federal court to hear the case.
I don't understand the federal court.
I see it as the best route.
Can't you just go and speak to Judge Bazile?
That was the trial judge.
We ain't heard anybody.
I don't think that.
Just talk to him. Just talk to him. Just tell him if you let us back in the state, we won't bother anybody.
Look, I do not think that this case will be resolved in Judge Bazile's court or probably any other court in the state of Virginia. I believe this is a court battle that could go all the way to the Supreme Court. Our problem is that in order to appeal the judgment of conviction, we would have needed to do so within 60 days.
Look what he recommends.
Given that it's been 5 years since that conviction, we have to find a way to get back into the court.
Wait for it.
Are you following? Now I've given this some thought, and I have a somewhat unorthodox idea on how to do this. My suggestion would be for the two.
Anyone want to guess what he recommends? Okay. Rule number 1, being a lawyer, do not let your client get arrested. Rule number 1.
You return to Caroline County, get rearrested, and then we will have
Look at her face.
Yes, it's an idea. I, of course, will be able to bail you out. We aren't going to do that. Right.
Stammers.
You can see how that was a mistake.
Yeah.
I understand. Look, I need to do some more thinking on this case.
Yeah, you don't think.
Bottom line is we are going to get you all
We appreciate it. We really do.
Yeah. All right. All right. Now, I encourage you to watch the movie. It's about 2 hours. It's on, it's on Amazon. It's on Google. You can find it anywhere. It's a good movie. But why did I play that scene? Far too often in ConLaw, you don't actually appreciate the fact that there are real people involved, right? That they're actually human beings whose lives are being impacted. And this is a case where I think it's important to put a face on the case, because these were two people who weren't looking for fame. They weren't looking for any sort of notoriety. They were two people who loved each other, who had a family, who had kids, and they wanted to go live where their family's from, which is Virginia. And they couldn't because of the law that was in effect at the time. Eventually, the lawyer found a way of litigating this case that did not require them to get arrested. That was just insane. I don't recommend your client go to jail. It's just not a good idea. What they did was they filed what's called a writ of habeas corpus, where they try to challenge a conviction after the fact. They knew they were going to lose in the trial court. They knew they were going to lose at the state Supreme Court. In fact, if you watch the movie, at some point they just moved back to Virginia during the litigation, risking it. They didn't want to live in D.C. anymore. One of their kids, I think, got injured in a car crash, and they wanted to live in the country where they're from. They moved back to Virginia. They lose in the trial court, they lose in the appellate court, they lose in the Supreme Court of the state, and it gets appealed to the U.S. Supreme Court, which is where they want to go all along. Okay? The Supreme Court oral argument in this case was quite remarkable. I want to play some of the clips from the argument. The government defended this law, and the government said they actually needed this law. Okay. What was the government's justification for this law? Let me play this clip. I know a lot of videotape, but there's some good stuff.
This statute serves a
This is the lawyer for Virginia arguing.
legislative objective of preventing the sociological, psychological evils which attend interracial marriages, and is an expression, a rational expression of a policy which Virginia has a right to adopt.
In other words, they were defending the law, and they argued that the law served a rational purpose. What was that rational purpose? I'll play this clip.
Interracial homes. The lawyer for Virginia argued that
Interracial marriages are detrimental to the individual, to the family, and to society.
In other words, the reason why the state banned interracial marriage was to protect the children. What children? The children that would be born into those unions, right? At the time, it was actually a crime to have a child out of wedlock, right? It was actually basically illegal to have a child if you weren't married. I'll use the word legitimate, that's the phrase they use, but children born out of wedlock could not inherit property. They could not do various things. So the only way to have kids was to get married, and this law prohibited the marriage that could lead to children, right? So they weren't just trying to stop interracial marriages, they were trying to stop interracial children, right? It was about the kids. It wasn't just being in the union together, or it wasn't just about cohabitation, okay? Yeah, next line.
he added,
Interracial marriages bequeath to the progeny of those marriages more psychological problems than parents have a right to bequeath to them.
In other words, by virtue of having a biracial child, the parents were giving their children a disability, right? They were giving them a stigma. Now, of course, why is a stigma? Because a bunch of racists around, right? That's why the stigma exists. But it was this policy that allowed these children to come into the world in this capacity. So then you have Hugo Black, right? Who, again, I mentioned this earlier, he was a former Klansman. He actually was a member of the Klan. But he had a second awakening on race issues.
Is there any doubt in your mind that the object of these facts, the basic premise on which they rest, is that the white people are superior to the colored people and should not be permitted to marry?
All right. All right, so the court holds that indeed this law was not supported with adequate justification. That the basis for this law was solely white supremacy, right? And the idea that interracial marriage, abandoned interracial marriage was premised that one race was superior to the other. Now you may ask, wait a minute, isn't it equal, right, that a white person can't marry a black person can't marry a white person? This case repudiates Plessy far more than Brown did, right? This says that separate but equal is not equal, right? Not just in the context of education, but you can have racial classifications. And this case gave birth to the modern framework of how the court considers equal protection cases. Okay? Let me give you some of the background here. Right? This case gave birth to what we now call the tiers of scrutiny. And I want you just to listen for a bit, but I'll let you ask questions in a minute. Okay? We're called the tiers of scrutiny. The first step in modern equal protection doctrine is we ask, how is the government classifying people? Right. Is the government classifying people based on race? Is the government classifying people based on sex? Or maybe they're classifying people based on their age. For example, you have to be 16 to get a driver's license. A 15-year-old can't get a driver's license. Or maybe you have a sex-based classification, right? Maybe women aren't allowed in certain combat roles in the military, but men are. Or maybe you have a racial classification, right? Black students go to this school, white students go to that school, right? The first step in any sort of modern equal protection case, we ask, what is the government classifying people based on? Right? Is it race, is it sex, or is it age? The court treats these different kinds of classifications differently, right? We see that racial classifications are called suspect suspect classifications. What does suspect mean? Think of like suspicious. That is, when the government classifies people based on their race, the courts get very suspicious, basically saying, you probably don't have a good reason for racial classifications. You're probably doing this because of white supremacy, right? Because some sort of supremacist notion. That's why you're doing this. That's more or less what the court said in Loving. Right? But what about age, right? We say that age is a non-suspect classification. Right? Why is it non-suspect? Because treating kids differently is not a big deal, right? Maybe New York lets driver's license at 18, Texas at 16, California at 15, right? Different states have different approaches to age because everyone gets older. When you're a kid, you're not more mature, but when you get older, you get your license, right? So there's not much suspicion when there's an age classification. Sex is somewhere in the middle. At least maybe for now it is. I don't know, right? Age is what we call quasi-suspect classification, a quasi-suspect classification. Because there may be some good reasons why we treat people differently based on their sex, but we're still somewhat nervous when we see that. Right? So the first step with any sort of equal protection case on the exam or otherwise is you say, what is your classification? Is it a racial classification? Then we have suspect classification. If it's sex, it's quasi-suspect. And if it's age, it's non-suspect. Okay. Next part you're going to have to memorize. The Corps has developed 3 different tests for each of these 3 different classes. The first test is what's called strict scrutiny. Right? When you have a racial classification, you review that classification with strict scrutiny. I'll explain what it is in a minute. When you have a racial classification, you review it with strict scrutiny. I can't spell today. What about the middle one? When you have a sex-based classification, you apply what's called intermediate scrutiny, kind of like middle scrutiny. Intermediate scrutiny. And when you have sort of a non-suspect classification like age, you apply what's called rational basis scrutiny, which we've mentioned this phrase before, right? We've mentioned these phrases before. So I'm going to give you a preview, right? The phrases strict scrutiny and rational basis scrutiny are used in many contexts. This is about equal protection, right? Equal protection. But in due process cases, you have these same phrases. That when you have a case involving the due process clause, laws that violate fundamental rights are reviewed with strict scrutiny, right? With due process cases, laws that violate fundamental rights, fundamental liberties, are reviewed with strict scrutiny. And laws that violate non-fundamental rights are reviewed with rational basis review. We'll go over this again later, but I want you to understand this point now. The phrase strict scrutiny means one thing in equal protection cases and something else in due process cases, right? Indeed, the phrase strict scrutiny is also used in free speech cases, meaning something completely different, right? So you have to understand what context are you considering these issues before you decide them. Okay? Yes, Braden?
When it comes to like laws that are, I guess, either for or against like gender identity.
Yep.
Where exactly would that fit?
Unclear. right? Justice Kennedy, who wrote almost all the gay rights cases, never quite said what tier of scrutiny is applied in an equal protection clause. He just never did. So it's an unresolved question. But good point. I'm sure eventually the argument will be that discrimination on a person's sexual orientation is sex-based discrimination, which might make intermediate, but we'll see. Courts haven't resolved that yet. Okay, one with me. All right. Let me give you the tests for each of these three tiers. Okay? Here's the test for strict scrutiny. Okay? The classification is narrowly tailored to serve a compelling state interest. The classification is narrowly tailored to serve a compelling state interest. Josh, what the hell does that mean? I memorized this phrase in law school. I didn't know what it actually meant. I want to actually explain to you what this phrase means. Okay? So we start with the classification, a racial classification, segregation of schools, ban on interracial marriage, right? Why is the government using this racial classification? They're trying to achieve a compelling state interest, right? Some really important goal the government's trying to achieve, right? Some really important goal. What was the goal at issue in Loving? What were they trying to achieve? Preventing interracial children from having stigma. Was this interest compelling? I don't think so. In fact, the court says that the real goal is white supremacy. So in Loving, the state was not achieving a national, compelling state interest. But let's try a different case you studied in which a racial classification was upheld. I'm talking about Korematsu, right? In Korematsu, the court upheld a racial classification. Only Japanese people had to report for exclusion. Is national security a compelling state interest? It is. Okay, but then you have the other part, this thing of narrow tailoring, right? What does that mean, narrow tailoring? Think of a suit, right? You can buy different kinds of a suit. You can go to, Walmart or Sears. Sears doesn't even exist anymore. You can go to Walmart, right, and buy a suit off the rack, and it won't really fit you. It'll sort of hang off. Maybe the sleeves are too long, right? It's very loose on you, okay? Or you can go to a tailor, and they'll measure you. They'll cut the fabric. They'll make you a custom suit. It's perfectly tailored. It's narrowly tailored to your body, right? Which one fits better? They're the custom-made suit. When you think of strict scrutiny, think of the custom-made suit. In other words, you realize you're only using as much fabric as you need, not an inch more, right? It's narrowly tailored to fit your body. Whereas with, the Walmart suit, it sort of hangs off your body, lots of extra fabric, maybe you don't even need it. The use of race must be as narrow as possible, that you're only using race to achieve that interest and not for any other reason. Now, you may ask, in Korematsu, was the use of race narrowly tailored? Probably not. I don't think the court applied this sort of framework back in the 40s. But you'll see in the affirmative action cases we have for tomorrow, or Thursday, the court says that yes, that the use of race in higher education is narrowly tailored. You're not using it more than you need to, right? That race can only make a certain component of your admission score, but not the entire thing, right? You can't have a race being the sole deciding factor, but if race is one of many factors, then it's okay. Right? The concept of narrow tailoring is how precise is your program? How little race, fabric, right? How little race is actually being used, right? That's the goal of strict scrutiny. Say, how broadly are you using race, or is it being used narrowly? And this will make more sense when we do the affirmative action cases. One more point. With strict scrutiny, the government has the burden, right? When the government wants to classify people based on race, the government needs to show that they have a compelling interest, and the government needs to show that their approach is narrowly tailored, right? It wasn't the burdens of the Lovings to show why this law is unconstitutional. The state of Virginia had to demonstrate why the law was valid, and they could not meet their goal. This will make a lot more sense when you do the reading for Thursday. I'm doing it now deliberately so you're prepared for it. Okay, any questions on strict scrutiny? All right, I'm going to give you the next two tests to complete your notes, but it won't make a lot of sense, right? It'll make more sense when we do the gender cases a little bit later. Okay. With intermediate scrutiny, you ask, the classification is substantially related to an important state interest, right? You ask, is a classification substantially related to an important state interest? Notice how it shifts, right? With strict scrutiny, the interest must be compelling, right? Compelling. But with intermediate scrutiny, the interest only has to be important. Which is bigger? Important or compelling? Well, your compelling's over here, importance over here, right? So with intermediate scrutiny, you can get by with a little bit less of an urgency. And instead of narrowly tailoring, you can only have substantial relationships. So that's maybe not, maybe not a Walmart suit, maybe like a Macy's suit, right? So a little bit, a little bit baggy, but still kind of fits you well. Okay. The last test we have is what's called the rational basis test. This is very deferential. We ask the classification is rationally related to serve a legitimate state interest. Okay? Is the classification rationally related to serve a legitimate state interest? Now the state interest doesn't have to be compelling. It doesn't even have to be important. It just has to be legitimate, which is more or less anything. And here, rationally related means is in the ballpark, right? Is, does the suit sort of hang off your body? Yeah, it's close enough, right? You're wearing like a bathrobe, good enough, right? You don't even need a suit, right? It doesn't have to even fit you well. You're wearing a burlap bag even, right? Rational basis is very deferential. The government almost always wins the rational basis test. Indeed, the person challenging the law has the burden. The burden is not the government. It's the person challenging the law. Right? The person challenging the law has the burden.
Who has the burden on the
I was going to get there in a minute. Thank you. The government has the burden here as well. Make sure your notes are always complete, right? The person challenging the law has the the government has the burden in the middle one. Now, you've studied this before. And I'll give you phrases that might help make this make sense, right? You might say that the rational basis test applies a presumption of fill in the blank. That's it. Right, that the rational basis test applies a presumption of constitutionality. And if you go back to your notes in the due process clause cases, you'll see this, right? Like in Caroline Products and Lee Optical. There's a presumption of constitutionality that the government's presumed to prevail. Whereas you might say the strict scrutiny one is presumption of liberty, right? Because the burden is on the government to show their law is valid. Okay? After class, go back and compare this framework to your notes in the due process clause. You'll see very, very similar approaches. But doctrinally, they're a little bit different. And on an exam, please listen to this point at least, do not apply the due process clause framework for an equal protection case. Do not apply due process framework for equal protection. Flip side, don't apply equal protection for a due process case. So if you have a case in which people are being classified on the basis of their race, don't talk about the due process clause. If you have a situation where a right's being violated, right of contract, for example, don't talk about the equal protection clause. Keep your clauses straight. The Supreme Court conflates them all the time. I don't. So you have to keep them separate. Okay, right on time. Questions on this framework? Yes, sir. No, which drives people nuts. Due process does not have intermediate scrutiny. Drives people nuts, I know. If anyone's interested, the Red Mass is tonight. It's at the Co-Cathedral down the street at 6 p.m. They have a mass, and all the lawyers and judges in town usually go. I go. I'm Jewish. What do I know? But I like it. It's nice. Okay. Anything else? All right, I'll see you later. Thank you.